My screen is visible to all. Can you see my screen?
Yes, sir, we can see, sir.
Okay. So this is how your application starts. Again, I'm repeating all the forms. Form 1 as an application, Form 2 for completing provisional specification, whatever it is. Then Section 8 declaration, and then Section 5 will be declaration of inventorship. Form 5. Form 5 will be declaration of inventorship, and Form 26 will be authorization of SE. If you are a small entity, you will go a small entity, startup or educational institution, you will file a Form 28. This all is filed with the application, and then uh, if it is a PS, you have to file a CS. If it is not filed, it will consider that application has been abandoned. Within 15 months, you have a right to withdraw. You can withdraw, and then publication will not happen. However, you can withdraw your application anytime before the grant. If you withdraw, you have to file a Form 29 and you can withdraw. If you have before the expiry of 15 months, if you withdraw, your application is not getting published. If you are withdrawing after the request of examination, then then the fee paid for the request for examination will be refunded if first examination report is not issued. Now comes application. If you request for, if you don't request for early publication, then 18 months it will be published. After expiry of 18 months, within 1 month it is published. Or if you are going for a request for publication, you will file a Form 9, and within 1 month from the date from the request, it will be published. After publication, you can request for examination within 48 months from the date of application. Then, if request for examination you are not filing, it is considered that you have withdrawn the application. However, if then publication within 48 months, if you have gone for a request for examination, there can be two types of examination one can opt for. Request for examination can be asked for by an applicant or an interested person. Who is an interested person? Who is working in the same field or or engaged in the same field. Then an applicant, while expedited examination can only be asked for the certain categories of the applicants. Though, what are those categories? If India is a applicant, where India, which in PCD filing, if India has been chosen in ISA or IPA, then yes, that applicant can go for the expedited examination. Startups, a small entity. If all individuals are the applicant with one female applicant, yes, they can go for the expedited examination. Government department, government company, government finance institution, government notified sector, as well as government statutory institution constituted by the government or controlled by the government can also avail the facility of the expedited examination. Then comes if there is an arrangement under foreign patent office (FPO) or Indian patent office. If that is the case, then yes, under that arrangement, expedited examination can be gone for. Can be opted. Now, what happened in examination? There are certain stages which will happen. First is after your request for examination, the controller will refer your application to examiner. After referring to your examiner will conduct a search and create an examination report, and thus examination report will be submitted to the controller. Controller will dispose of the examiner report in 1 month. After the disposal, within 1 month, or FER or FSO is issued. However, the timeline might differ. In ordinary, the examination report is submitted in 1 to 3 months, while in expedited, it has to be submitted within 2 months. In examination report, it has to be submitted. It takes 1 month here, 1 month there. The same disposal examination report takes 1 month. After that, issue of FER or first statement of objection or first examination report, whatever you call. In first, it takes 1 month from the date of disposal of examination report to issue an FER, while in expedited, it is 15 days. After that, the applicant has to reply to the objection raised. Either you can amend it and comply with the application, or you can further contest it. It's up to you. And from the date of FER, your deadline for to put your application in order for grant starts. It is 6 months. You have to put your application in order for grant. When I say application in order for grant, that means you have to comply with all the requirements and satisfy all the objections which has been raised. This is called application in order for grant. This timeline can be extended only for 3 months. Then, however, once the 6 months is there, you have put your application in order for grant, controller will again look into it, and then it will either refuse it or grant the patent as he deems fit. Now, within the 3 months, what happens in expedited? Expedited, the 6 months scenario is same. Extension of FER is also same. However, within 3 months from the last reply from within 3 months, controller has to take a decision. Or from the last date to put application in order, controller has to take a decision. Whichever is the earliest, controller will take a decision at that time. This is the difference between examination and expedited examination. Later, once the grant of patent is done, there are certain compliances, regular compliances, which is there, payment of renewal fee is there, and annual filing of the working statement has to be done. Okay, this is in general understanding what will happen. What happens when we are going for an examination. Now, priority date we have already read yesterday, and data filing, or generally the data filing of patent application is the data priority. However, if there is a PS and CS filed, then there can be 3 scenarios. If CS is filed after PS, data filing of PS will be considered the data for the priority date of claims. If CS is filed after PS1 and PS2, then we will, if claim is wholly based on PS1, data filing of PS1, claim is wholly based on PS2, data filing of the PS2. That means which provisional specification was first disclosed, that will be taken. However, if it is based on more than one, that is PS1, PS2, PS3, whatever it is, we will take the latest one, the last one, which is later. That is considered as the priority date for the claim, because we consider that it was only in the last claim where it was completely disclosed. Then go over CS2 after conversion. Same thing. If CS2 is converted after into a PS, then date of disclosure and relevant specification will be considered the claim, because now there can be 2 types of claim. One filed with the CS1, another filed with the CS2. So whenever they were disclosed in that relevant specification, we will consider that as a priority date of a claim. Then come post dating. Post dating is in the event of post dating, whatever the date of filing which has been post dated, that will be considered as a priority date. If your divisional application with PS and CS is FMA, that is first mentioned application. In divisional application, the date of filing of FMA works as a priority date. If it is a convention application, the date of base application will be considered as date of filing of base application will be considered as a priority date. Okay. Publication, we have already said, publication, there can be secrecy direction under section 35, or it can, if it is a secrecy direction under 35, controller, what controller will do? Controller just tells that the information is, the invention is related to the defense purposes. And since it is related to the defense purposes, yes. For your understanding, yes. Controller says this that it is related to defense purposes, it will direct for the direct for prohibiting of the publication of the application and inform the government as well as inform the applicant. The government on reference will look into it and will see whether secrecy direction should be continued or should be revoked. And if it is says that publication can be done, it can revoke the direction and notify the applicant accordingly. Controller will do that. And suppose secrecy direction, government is also of the view the secrecy direction should continue. If secrecy direction is continuing, then you can ask for periodic, it will be periodically reviewed on 6 months, or you can request for the secrecy direction to be revoked. If you are asking for the reconsideration, if control finds it reasonable, it will inform it to central government for the review, and on reconsideration and review, if government wants, it can re-evaluate whether the secrecy direction are still required or not. Then it can give the notice to revoke the direction to controller. Once the controller revokes the direction, the result of every reconsideration, revocation or non-revocation has to be communicated to the applicant within 15 days from the date of receipt of the notice by the controller. Okay. Now, government can suo moto also do this. In order for grant, if you are in secrecy direction, your application can move forward for up to the stage of in order for grant, but it will not be published. And no patent can be granted till it is in secrecy direction. However, because of this, if you are suffering hardship, that is you are losing money and other things, that is government is of the view that government is using it under section 100, 101, 103, then yes, you are entitled to get a solatium, and the solatium will be reasonable based on the following factors: novelty and utility of the invention, purpose for which it is designed, and other relevant circumstances whichever is considered fit for by the central government. Once the patent is granted. If whatever the period in which your patent was under secrecy direction, for that you don't have to pay the renewal fee. And no appeal shall lie from any order of the controller passed in this respect. Controller or government, anyone's order, this is non-appealable orders. If they have decided that this is a secrecy, there has to be a secrecy, then secrecy direction will be given. You cannot challenge that. Then comes examination. One basic thing is no request, no examination. Once the publication plus request, then publication plus request for examination is necessary to initiate the process of examination. Request can be made by any applicant or person interested. Please remember that request for examination can be filed by interested person also. As I told you, person engaged in same field, promoting, researching anything, that is, he is a person interested. Then request for examination is filed in 18. Remember, Form 9, publication, double it, Form 18 for examination. And for expedited examination, 18A. Examination, section 12 talks about examination of application hurdles. The same thing which I have told, that is referred to the earliest by controller to an examiner. And then 3 things are done. 4 things are checked for this, whether all the requirements of Act are being complied with, or there is a lawful ground of objection to this, or any anticipation investigation is done under section 13, that will be done, and any other matter which is prescribed for them to look into it, they will go for that, and on basis of it, an FER is issued. I have circulated a type of FER earlier class. You can look into that to understand how FER is issued and what kind of a formality examination is done. I think I shared it with you. See, just to show you, this is how FER is issued. You already have this copy with you. You can go through this just for better understanding. So this is how it will come. So examination report for statement of objection as per the 24B. Please remember these sections because these rules, few rules are important. For example, 24B, 24C, these are important. So remember them. Then comes C. There is a summary of report. They are talking about novelty, inventive step, industrial application. Invention under section 21A. Then they go for whether patentability, non-patentability. That is criteria of section 3AP. Okay. Then comes section 10 related questions, 10.5 and 10.4, basically, under which clarity, conciseness, definitiveness, and supported by the description and the scope is checked. Then the detailed technical report is here. They have cited the patent literature. This is the prior art which they have found. Okay. And which claim is our cited document is relevant, claim 1, for what they have said there. Okay, here they have said entire document is there, and they have again talked about entire document. Okay, 16, 18, 17. Application was filed on 19. See, it was in 2019 application was filed, and all those are before the filing date, or the documents have been shared. Now they are again talking about inventive step. Okay, lacks inventive step obvious with respect to D1, D2, D3. See, here please see, there are two types of literature. One is a patent literature and another is a non-patent literature. They have not cited any non-patent literature, but patent literature has been cited. Now please see novelty. They have said yes. That means they have not raised any objection on novelty. However, inventive step, they have no. Okay. And they have raised objection on the inventive step. That's why here comes inventive step. They are talking. This is an obvious in this view. And they have cited which document, why that is relevant, and how this will be considered that this can all the teachings can be combined, and hence it is an obvious invention. You have to reply to this obviousness. Then comes non-patentability. They are saying under section 3B it is non-patentable because it is intended to kill mosquitoes and it will cause serious prejudice to animal life and environment. Now comes sufficiency of disclosure. Abstract. They are again saying we have discussed how to write an abstract, and this is the objection they have received. The abstract shall concise a concise summary of the matter, content, the specification, and necessarily indicate clearly what three things it should clear: technical field to which it belongs, technical advancement of the invention as compared to existing knowledge, and principal use of the invention. When you are drafting your abstract, these three things should be there. That's what they are looking for: technical field to which the invention belongs, technical advancement, and principal use. As we have discussed earlier, just go for that. Then comes scope. Then they are talking about that further comprising includes synonyms are not allowed in subordinate claims. What they are talking about is scope of that it is not properly drafted. They are raising the objection that please don't use. The principal claims shall be reworded in such a way that novel, inventive, and characterized by in that. So they are asking that it should be in part of two parts claim that we have discussed, gypsum claims. Right? It's not necessary that this objection has to be complied with. You have to defend your position. If you don't need that characterized by that is not needed, you can always object and contest the objection and give your view. If yes, very important point here. If you contest the examination, what will happen? If you contest this particular any objection, they will look into it and they can, and you can ask for the hearing. In hearing, they will hear you out and then only decide. The very important part of the hearing is, which will be used in various places. See, any officer, any government office does not decide anything which is going to harm you without hearing you out. Any decision cannot happen. This is a set. This is a rule based on the you can say audi alter partem, that is, you have to listen to the other party before deciding. This is a principle of natural justice. Without going into the legalese, the best thing is you have to remember that since your interests are involved or anybody else whose interests are going to be hampered, he has a right to be heard before the authority who is listening it, who is going to decide. So without listening you, they cannot go for any order which might harm your interest. Because of this, this is the contest in which hearing is allowed. So you can always ask for hearing. If you are not asking for hearing and you have been given the opportunity to hearing and you have not appeared and you have not availed, then it is considered that it was satisfied and government can proceed. So similarly here, if hearing is happening, you will go before the controller and say that this is my argument. If he takes your argument, is convinced by your argument, he will pass a favorable order to you. Otherwise, he will ask you to make amendments and conform to the requirements what he deems fit. Similarly, the formal requirements are there. For example, format of drawing is not complying, statement under the undertaking, statement under the section 8, they are asking for section 8 undertaking if this is not there. And similarly, other documents on record, they have said that these documents of request are with me. Right? Okay. Now we will go back. See, while discussing every classes, I have not discussed yet what are not the patentable subject matter. Since examination, this will also be checked. So I decided to discuss it here. So there is a section 3 and section 4. Section 3 talks about what is not invention and section 4 talks about what is not patentable. Section 4 is very simple. Anything which relates to atomic energy is not patentable. That means even if it is an invention, it qualifies the definition of invention, I will not give you patent. This is your policy. So in atomic energy, we have decided that anything related to atomic energy will not be patented. No patent shall be granted in respect of invention relating to atomic energy falling within the section of one of this. And it talks about these 4 things in which you will not get any patent. First is the atomic energy related inventions. If prescribed substantial or radioactive substances are there, or safety in atomic energy operations, if your invention relates to these, you will not get patent because that is not a patentable subject. Now, before going through the what is not invention, section 3, please remember it is very important not only for your exam but also for Viva. Most of the Viva starts here and finishes it here. Okay, so read it, understand it, and if there is any issue, consolidate it from your any other reading material which you might find. Now go for section 3, which are not considered invention. Please understand the inventions which are here, or you can categorize them in 3 parts. You can categorize them in 3 parts. Understanding this, first is whether when I'm talking about invention, we have a definition which says that new product and process having inventive step and capability of industrial application. This is the 3 criteria on basis of which invention is there. So what we are talking about, if something is not novel, something is not worthy of getting qualified for this criteria, this is what will not qualify to become an invention. The first two are, in general, they are saying that it already existed, or it is so trivial, or it is not worthy of being an invention. Then first two are those. Then comes then C, D, E, F. These are related to the invention, inventive step, or novelty criteria, in which they will say you, if you are claiming this should be the additional requirement which will be fulfilled. If it is not fulfilling these requirements, it will not be considered as invention. We will discuss this all just to give you an idea. So first two are clear cut. They say that this is not because of these in general, these are not the subject matter. When it comes to, for example, in C, D, E, this is that you are creating something novel or something which should have an inventive step, but it should follow a particular criteria. Otherwise, I will not consider it as an invention. Then there are certain processes which we say that they are not going to be considered as invention. For example, method of agriculture or any medical methods as prescribed here are not considered as invention. Then plant and animal as a whole or part thereof are also not considered the invention. Then there are certain other exceptions. These are also the subject matter which I am taking out. So first, remember that there are few things which are subject matter which I'm taking out. In this subject matter, few are specified subject matter which we have given, and few can be protected under different laws as a different form of IP, not the protection of patent. For example, LDMA, literary, dramatic, musical, and artistic. This one. Literary, dramatic, music, and artistic work, or any aesthetic related or cinematography. This is like you cannot get a patent on movie. You cannot get a patent on a novel. You cannot get a patent on music. Here you get copyright. So all those materials are excluded from the list of patent. They are not invention. These are creations, and these creations get the protection in the copyright. Similarly, the integrated circuits, the layout of integrated circuits can give a function, right? If the design is changed, their functionality might change. That's how the layout design of semiconductor chips is important. However, this is not covered under the patent. You get a protection under semiconductor integrated circuit layout design Act 2000. In this, you have to prove that this is original, this is original, this is distinct from the earlier existing, and this is not same to earlier ones. Same when I'm talking about that this has a distinguishing ability from the existing chips. If that is considered layout design, you can get a protection there. However, and TK is nothing but a prior traditional knowledge. So now we will go with one by one each and every thing with an example. First, the invention which is frivolous or which claims anything obviously contrary to well-established law. So in short, I have written so that you can always remember section 3A. Please remember subsection has to be remembered here. You cannot forget the subsections. Here section as well as subsection both are important. Section 3A talks about frivolous invention or the invention which are contrary to natural laws that will not be considered as an invention. For example, if you say that I am going for a perpetual motion machine. So perpetual motion machine or 100% efficient machines, we can understand this is a contrary to natural laws, so it will not be patented. Then comes primary or intended use or commercial exploit. If your inventions use or commercial exploitation is contrary to public order and morality. That means you have devised a good method of theft or a brilliant method of counterfeiting the currency. Then, since it is against the public order and morality as well as law, it will not be given, you will not get a you will not get a patent here. Then comes if you cause serious prejudice to any life, whether it is human, animal, plant, or environment. If your invention prejudicial to life, health, or environment, then you will not get the patent. The general example of this, in which we have you don't get patent, is cloning of human animals, modifying germlines of human beings, modification of genetic identity of animal without substantial medical benefit to animal or man, processing of preparing seed, genetic material, comprising element using adverse environment effect. Human embryos cannot be exploited for the commercial exploitation. All those. This is all considered as a public order, morality, prejudicial to life, health, and environment. Okay, so 3B is prejudicial to life, health, and environment, and against the public order and morality. Then you will not get the patent. Then comes the bigger risk, where you might get patent if you have something additional. Then yes. For example, they say C is very clear. C, that mere discovery of scientific principle or formulation of abstract theory or discovery of any living thing or non-living substance occurring in nature cannot be patented. So when I'm talking about this, what are the scientific principles? For example, Newton's law of motion or gravitational theory. The gravity was always there. What you have decided, you have identified that these are the laws. So this is a scientific principle, it cannot be patented. Then formulation of abstract theory. There is a theory which says that mere exposure effect, if you have ever heard of it, mere exposure effect is in psychology we say that if you are continuously being exposed to a person, you are not talking to that person. Suppose you are walking in a park and you are regularly looking, regularly seeing a person. Okay, so the first thing which happens is you will have a positive feeling about it. You will not develop negative feeling unless something negative happens. You will always develop a positive feeling because of mere exposure effect. Though you have never talked, you have never interacted, only because of being exposed to that, you will always have a positive feeling about him or her, whatever it is. So if this is called mere exposure effect, this kind of abstract theories cannot get patented. Then comes discovery of then naturally occurring living and non-living. They were already existing. You were not aware. So there are various species which are still getting discovered. For example, there are certain isoetes. Isoetes is a plant. Some plants species still we get to know this are existing and we were not aware, and we are still documenting it. Some fungi we get to know that this fungi we never it was not documented, we have never known that this exists. So if it was existing but you were not knowing, that doesn't mean that you can get a patent on it. However, if you isolate something which was from them, which could be isolated, and then it can be used, then the process of this isolation as well as keeping it intact outside can be patented. How you are protecting it, isolation, it is not getting degraded or denatured. If that is the nature of that particular thing, for example, if you extract something from the plant and if you put it out, it gets denatured or it does not survive in outside environment, but you are stabilizing and having a shelf life and it increases shelf life, then yes, this thing can be patented. So something which is not a discovery, which is not existing, can be patented. If you have some input there, then that can be patented. Okay. Now comes mere discovery of a new form. So section D, 3D, yeah, it has also been notorious. It is also notorious for being as a third dimension of the Indian Patent Act. The 3D is talks about that mere discovery of new form of a known substance will not be considered as the invention. Similarly, mere discovery of new property or new use of a known substance. So form, property or use of a known substance is not patentable. Okay, and then comes third part, which talks about a known process. See, first we are talking about known substance and another part is known process. So if mere use of known process, machine or apparatus, that is also not patentable. When they are patentable, when they can become a patentable is this. We say if there is a new form, it should demonstrate an enhanced efficacy. If enhanced efficacy is there, then yes, it can be patented. So, and what is enhanced efficacy? It was in Novartis case that it was discussed, and it says that significant increased therapeutic efficacy is only patentable. Test of efficacy under section 3D was laid out. It said that efficacy means ability of producing of a desired or intended result. Test of efficacy would depend upon the function, utility or purpose of the product under consideration. In case of a product, the test of efficacy can only be therapeutic efficacy. Not all advantageous or beneficial properties are relevant, but only such properties that relate directly to the efficacy are relevant. So it is a strict, they have gone for that. We will not see that this is not beneficial or there are other advantageous property. The only thing you have to improve is that the efficacy has improved. That is, if it was, the desired results are getting produced in larger probability or in better proportion, then yes, you can talk about this, you can get it patented. Otherwise, you cannot get patent on that particular new form. The form's explanation is given down that salt, ester, ether, polymer, metabolite, pure form, particle, isomer, complex combination and derivatives. All this will be considered as the same substance unless efficacy is significantly different. Then mere discovery of new property or new use or a known. Let's go to second part. Known, you have discovered a new property or use of known substance. It will not be patented unless there was a difficulty in exploiting this new property and new use. Unless there was a difficulty in exploitation of this new property and new use, and that has been overcome by the inventor, then this is the invention. Otherwise, it is not. Similarly, use of known process, machine or apparatus is not considered as patentable unless there is a new product getting employed or a new reactant has been used in that process. So either the process, machine or apparatus results into a new product, or it gives you or any new reactant is being used in the same process, then yes. Otherwise, you cannot get a patent. So remember this simple 3D is talking about known substances and known process. Known substances is talking about form as well as new property or use. Done. Then known process or machine apparatus if you are and when it can be patentable, first, if it has an enhanced efficacy, then it can be patented. If the use of known process machine or apparatus is not using is resulting into a new product or employing a new reactant, it can be patented. Done. Then comes 3E and 3F. 3E and 3F are the same in their understanding, but 3E relates with the chemical, what is related to a chemical, and while 3F relates to the same type of concept in devices. So when I'm talking about mere admixture, it reads like this: a substance obtained by mere admixture resulting only in the aggregation of the properties of the component thereof or a process for producing such substances, then it is not going to be patented. Okay. Now, example of this can be, you have, for example, you have paracetamol. And there, paracetamol, everyone knows, that is antipyretic. And then there is a ibuprofen. That is, this ibuprofen will result into pain relieving. Paracetamol is also pain relieving. Both, if both are combined, pain relieving as well as the antipyretic property can come. If these two are getting combined, and we know this drug as a combiflam also, but if these two are getting combined, then nothing is changing. These are merely a mixture. Unless there is a synergistic effect, unless there is a combination effect. That means whatever the effect was, the effect is getting enhanced. Then yes, you can get a patent. For example, in our earlier classes, we discussed that there is a problem of mixing, right? Diclofenac and thiacolchicide. They were not getting stable in an aqueous solution. There, in that invention, what was happening is diclofenac and thiacolchicide, both were getting mixed in a solution in presence of a stabilizing agent. And that stabilizing agent was not was preventing their degradation. Since there is this benefit and this additional advantage or this additional functional effect, because of which it is not now mere admixture but a invention. Because of this, the chemicals will that kind of invention can be patented. So there are certain things it talks about. If working interrelation produces new or improved result, idea of working interrelation is patentable. If there is a synergistic effect is that what the combination effect is more than that. Similarly, combination invention, same thing, that they are, the basic understanding is that sum of individual effect, more than the sum of individual effect, is being obtained. Then yes, otherwise no, you cannot get the patent here. Now similarly, it is in, we discussed it in chemical, but there can be that I combine two devices which already exist. For example, very crude example, you have seen the pencils with a cap, with the rubber installed in it. This is mere arrangement or rearrangement or duplication of known devices. So you have only arranged that this is a pen, this is a rubber will help you in erasing, and it will help in writing. This arrangement will not result into the patenting invention. Now similarly, if you have a camera and a phone, right? Camera and phone, you combine it and created a new thing. That this can we can talk as well as we can click pictures. If there is nothing else, then this mere arrangement will not be patented. So what is the requirement when such kind of arrangement, rearrangement, or duplication of known devices which can function independently can be patented. So very important is that if there is a new result or it becomes more efficient or more economical. So what is saying merely juxtaposition is not patentable. However, if there is a better result or more economic significance is there, it making more sense, then yes, that particular thing can be patented. Then said working interrelationship is necessary. Working, more important thing is we are saying both should not function independently. If they are functionally independent, then it is not patented. G is not there, G has been deleted. So remember 3G is not there. Then start with, or you can remember G से गोल, तो गोल हो गया है, गायब है, गोल गायब, whatever you remember, 3G is गोल गायब, whatever it is. So it is not there. Then comes H, H for horticulture. Method of agriculture and horticultures are not patented. Simple thing is these are the conventional methods in which we were already using it. Intercropping of leguminous plants, you might have heard. Okay, that enhances the fertility of the soil because leguminous plants have the rhizobium bacteria in their root, so they help in for fertilizing the soils better. So this is conventional method. In open feed, we do that. You cannot get it patented. Come and go, okay, this is the method of agriculture. In this, fertilizer, the productivity will increase. Those kind of agriculture and horticulture methods not patentable. Then comes 8. Then there's medical methods. It deals with medical methods. It is 3EI. It talks about the process of medicinal, surgical, curative, prophylactic, diagnostic, therapeutic, or other treatment of human beings, or any process for similar treatment of animals. First thing, any diagnostic or treatment method for human and animals is not going to be patented. Second, in animals also, if you are using a process which can increase their economic value or or its product, that is also not patentable. Now, let's go to the increase in value of economic value of animal. If you have some device because of which, suppose the sheep's wool quality is getting increased, or chicken is giving more eggs, those are not patented. That we are saying that it cannot be patented. Then comes, but prosthetic artificial limbs can be patentable because they are neither a diagnostic, therapeutic, or other thing. These are the support system for for humans. Then comes plant and animals. No plant or animal or any life can be patented or their part can be patented except one, which is microbes. That means you can get a patent on bacteria, you can get a patent on fungi, you can get a patent there for production of production and propagation of fungi, because those are the microbes and they are provided here. But you cannot get it on plants and animals. Then comes mathematical or business method or a computer program per se. You cannot get that, or any algorithm. See, the buying and selling of a goods. For example, you come and say, oh, I have invented e-commerce. From internet, you can buy and sell the goods. At present, it looks very easy, but there was a time when it was very novel concept that on internet you are selling this. So buying and selling of the goods on or carrying of a method of a business, something, you cannot get it patented. Then comes, how can you get a software patented? Software can be patented in two ways. First, it should, if software is embedded in hardware and you are claiming it as such, or there is a technological difficulty which software is solving, these two criteria are being met, or either of these is met, software can be patented. But in general, we claim software interacting with the hardware. Now comes LDMA. I have already told that any literary, dramatic, musical, or artistic work cannot be patented because these all are copyrightable material. If you want to remember LDMA. LDMA where TV and cinema, sound recordings, all those comes here. It will not be patented. It will go for Copyright Act protection under 1957, where threshold will be original. That's it, simple. You have expressed it, it's original, it has not been copied from somewhere else, you will get the copyright. It's the easiest IP to acquire. The moment you write something down, you get it. It doesn't matter whether what kind of, it does not have to be a literary work. Even if you present your ironing account in a lyrical way, they will consider it as a copyrightable material, not a problem. So then comes mere scheme or rule or method of performing mental act or method of a playing game will not be considered as patentable subject matter. If you are presenting an information and your presentation and information presentation method, the way you are presenting it, this cannot be a patentable subject matter. Further, topography of IC, that is layout design of under semiconductor integrated circuits, it's not patented. Then P talks about if there is a traditional knowledge, that traditional knowledge cannot be patented. Or from traditionally known component, you have identified few things and created an aggregation. At the aggregation and duplication of the known properties, a traditional known compound will not be patented. So we have understood 3 and 4 objection, how 3 and 4 objection will happen. To fourth, very clear, you are related to atomic energy, there is nothing. We don't have to even examine. We can always say it's relates to atomic energy, and thank you very much. Rest, there is a scope where you can prove that this is in addition to it, that is in addition to it. You should not consider it simply, you should not look into it like this. And this is another perspective to look at it. If you get convinced, you can get the patent. Now comes anticipation. We have already discussed what is an invention. So we have discussed invention definition, new product process, inventive step, industrial. New is a criteria of novelty. And then we have said the new invention means an invention of technology which has not been anticipated. This is the first time anticipation has been told. And anticipation can be by 2 things, either by publication in any document or by use. And we have a global criteria of this, that we will check in the global criteria. What is the threshold? Date of filing a patent application with complete specification. Please remember, date of filing a complete specification is the criteria. That is the date which is relevant for any invention. That's what we are considering. Now, the subject matter is what is most important is, idea is that it should not be in public domain or it should not be a form of prior art. This is what novelty stretches is. Now, if we go to this, search for anticipation by previous publication and by prior claim. So this is the, see, 11, 12, 11A, B we have read, 11 is priority, 11A is publication, 11B is examination, 11, 12 says the examination. Examiner, controller will refer to examiner for examination of the application. Then 13 comes where it says that what kind of search examiner will be doing. Examiner is going to search for the anticipation by previous publication and by prior claiming. So there is 13.1a, 13.1 and 13.2. 13.1a talks about that which publication is relevant. Okay. So there is a prior publication, then there is a prior claiming, and then there is a entire publication. The 13.1 deals with the patent literature in India. Please remember, 13.1 deals with the patent literature in India, while 13.2 deals with the any kind of literature, patent or non-patent literature in India or elsewhere. So what it says that publication in India or elsewhere in any document other than most. So except Indian patents, Indian patent document, everything else, including patents of outside, are under section 13.2. So this is called worldwide prior publications. We can refer it as a worldwide prior publication, and this as an Indian publication, Indian patent. Now another thing, please remember, when we are talking about, it's talk about that it talks about the publication, it talks about only the specification part. A 13.1 is focused on specification, while 13.1b is focused on the claim. So what is talking about? So we consider 13.1a as a prior publication, while when we are talking about 13b, we refer it in easy sentence prior claiming, just for our understanding, to remember it, the difference. So when we are looking for a prior patent document in India, that prior publication, we are looking for all the documents. This is the date of filing of your applicant's computer before that. Whatever it is relevant, but there is an upper limit, there is a limit from where it has to be looked. So any patent which has been published on or after 1st January of 1912. Okay. Why this magical date? What is this? Any idea? Any clue? What is this magical date? Why 1st January 1912? See, what they are saying that any patent made in India before 1st day of January 1912 is not relevant. That's what they are saying in this. So why it is that? Idea, I have discussed that. Okay. So remember history of patents? In history of patents, we discussed that Patent Act 1911 came into effect on 1st January 1912. Before that, there was no statute which could govern, Indian statute which could govern the patenting. Earlier, all that was the British UK acts which were governing us. So that was the first act, and so your patent, officially your patent started after 1st January 1912. Though you were making application, but they were under different law, not Indian law. So that's why there is a date 1/1/1912. If you remember this, this historical background, you will not forget this date. The 1st January 1912. After that, all the patent applications which are there, which are with us, are relevant for looking into the anticipation purpose. Where we will look into the entire specification, disclosure as well as the claim. Okay. Please remember, it's talking about a specification. Then go claim. Second talks about claim, but this claim refers to if in the patent application has been made in India, but it has been published after your application. Okay, it is getting published after yours, on or after the date of filing, getting published on or after the date of filing of your patent application, but it is claiming a priority. It has a priority date before you. Since it has a priority date before you, their claims are relevant for checking your anticipation. Okay. Then comes publication. Here, same thing. Before date of filing of complete specification, we will check whether it is anticipated by any publication or not. This is very simple. Any literature which is after the date of your filing is not relevant. Then let's take, if suppose there is a complete specification which is amended. If complete specification is amended before the grant, then the amended specification will again get examined and investigated similarly with respect to the, or as the original specification is getting examined. Now comes fourth part. Fourth part says only one thing, that all this requirement I have done under section 12 and I am doing an examination and investigation, everything. That does not mean that if your patent gets invalidated later, you will come and catch hold of. Simple. That all this exercise, examination, investigation does not warrant that you have a valid patent. Your patent can be invalidated later on. Okay. So simply, this is the summary. What are the relevant provision? Patent specification before filing date of applicant's complete specification dated on or after 1/1/1912. Okay. Then claims having priority date before filing date of applicant's complete specification. Then any other publication in India or elsewhere in any document, patent and non-patent. Patent is outside patent, not Indian patent. Indian patent is here. Okay. Then search is conducted with respect to date of filing of applicant suits. Now, consideration by examiner. What he will consider novelty and inventive. While considering the novelty, he will say whether prior art has been anticipated or not. When I'm saying anticipation, we say all the features of one document, present in one document, should be in invention. Another document I cannot refer. I cannot refer two documents to demolish my novelty. Novelty is E with respect to one document only. If there are three documents, for example, your invention is A plus B plus C. And there are documents which talks about A plus B, B plus C. But there is no document which talks about A plus B plus C. And then your invention is novel with respect to all these documents. Now, that's why it says the mosaicing of prior art not allowed in the novelty division. You cannot mosaic A plus B and B plus C both found. So hence, let's go further. You are not novel. This cannot be done. Then comes generic. Please remember, when we are checking the novelty, novelty is a fact-based question. That means it can be proved. There is a document which is clearly stating that all these features are here. These three features which you are claiming in yours are present in this document. So there is clear-cut proof. There is no interpretation chances, nothing. Since there is no interpretation chances, if the fact it comes before you, you have to produce the evidence that yes, whether that document is relevant or not, or whether either you amend yourself or you say that the priority date is different. This is the only difference you get. Because features are present and your features are present, this is a factual mistake, fact there. You will not be able to argue anything else. Then comes another part, generic and specific. Generic disclosure. If there is a generic disclosure, it will not take away the novelty of a specific disclosure. For example, if I have said that a particular handle is made up of a metal, right? If I have claim for a metal handle, then if someone is claiming for a copper handle or an iron handle, then this will not be considered as disclosed earlier, or that novelty is getting breached here. Okay. So please remember, it is not taking away the novelty of specific disclosure. However, other way around will be considered as taking away the novelty. If there is a specific disclosure, then generic disclosures novelty is taken out. This is a simple rule in generic genus species related claims. Now, onus of proving, then this novelty has some exception which we have agreed under statute, that is 29 and 34. So I will give you an objection on novelty. You can prove that they are, whatever the objection you are taking is falling under 2934. If that is the case, yes, you have one ground of defense there also. What is an inventive step? In inventive step, we have to check non-obviousness is getting checked. Non-obviousness is getting checked. The invention as a whole has to be considered. You cannot consider different parts are obvious. No, as a whole, if invention as a whole is obvious or not. By the teachings of the existing prior art, I will combine the teachings of 1, 2, 3 prior art, and we'll say that it looks that your invention is obvious. You have to say, no, this teaching should not be combined. And even if you are combining, this is a technological problem. This is a practical problem which I am facing. And that practical problem cannot be solved by this teaching methods. Hence, it should be patented. So invention as a whole to be considered. Mosaicing of multiple documents of prior art is permissible in inventive step. Mere workshop improvement will not be considered as invention. Then comes there is another concept that person is skilled in the art. This is called PSITA. Some will also call it as FOSITA. In UK, it is called FOSITA. That is person having ordinary skill in the art. Here we have person skilled in the art. As if you go, we have understood that person skilled in the art is of average skill and average genius. So now, if you are identifying, you have to identify the person skilled in the art, that who is the relevant person. Means, if you are working in a field of biotechnology, you need a biotechnological engineer, not a mechanical engineer. So this is first we have to decide in which field, who can be a PSITA. Then person skilled in the art, then I identify what will be the standard, which is a common knowledge, which is an average knowledge. A person with an average demeanor should know this. If he is working in that field, that will be considered as identifying the general knowledge of the or general standard of the or average standard of the PSITA on that priority date. On the priority date, he will be knowing this anyways. Then you will identify the inventive concept of the claim. This is what is inventive concept claimed, and how it differs from the prior art and the claim. If this difference is obvious, then the invention is obvious. If it is not obvious and their needs are ingenuity, then yes, it is not obvious and it should be patented. Then comes another inventive step in India. Technical advance or economic significance or both are needed to be established. Now, the last topic of today's is exception to anticipation. We have understood key novelty, how we are going for. The anticipation by previous application. So he is saying the publication of Indian patent prior to 1/1/1912 are irrelevant. We have already said that prior to 1/1/1912, we will not search. This exception to anticipation is why important. Exception to anticipation is important because not only for the novelty purpose, but there is 3 lines they will be using again and again. This for refusal to grant the patent, and patent revocation or invalidation cannot be done under these provisions. 29 to 34. Okay. So these are the exceptions. If you prove that this is, you fall under these exceptions and hence your novelty is not getting breached, you will not be denied the grant of patent, or revocation or invalidation cannot happen. So this is 33 and 34. So this is in 34, same thing it says. Okay. So now, so total there are 29, 30, 31 and 32 and 33. Now, when we are talking about this, we have to just remember how it is being claimed. Now, anticipation by previous publication, we have said anything prior to 1/1/1912 patent, we are not worried. Then comes, suppose is a prior publication, but I am proving that that prior publication was not with consent of patentee, applicant, or inventor. If I am proving that and it is not relevant, then we will consider it not relevant if you have to prove two things: that publication was without his consent and you have filed the application as soon as reasonably practical, ASAP, which you have written, as soon as reasonably practicable. The moment you got that this is the publication, this publication has been done without your consent, you have immediately filed the application in India. Then yes, that prior publication which was without your consent will not be considered relevant. Now, exception is what? If your publication is because you have commercially worked in India. If your invention is getting commercially worked in India before priority date by patentee, applicant, or inventor, or third party with consent, then that prior publication will be considered relevant. So exception is this. However, please remember, commercially working is allowed if that commercial working is necessary for the reasonable trial. If that commercially working is being done before priority date, then yes, if you can prove that it was reasonably required for the trial of my product or process, then it will be allowed. Okay. So this is the wrongful disclosure. If you understand, you can understand it as a wrongful disclosure. Okay. Then comes another one, 29. Then what it says that any publication, patent application has been made. If any patent publication has been made in contravention to right of true and first inventor or successor in title, that means any person who derives the title from them. If that is the condition, I have just, for our understanding, we are referring as a fraudulent application. Someone has made a fraudulent application because he didn't have a right and he has filed it. Now he has filed it. So any use or because of this fraudulent application, any use or publication has been done. So this publication as well as this use will not be relevant while checking the novelty. Now comes anticipation. But if you have already communicated the government or government authorized person for investigation of the merits of the invention, then that communication is also protected from being cited as a publication or communication which can take away your novelty. Then there is a public display. Now, public display is, it talks about three things. It talks about exhibition as well as a reading before a learned society. Okay. Now, it's not talking about a publication in any general. Please remember, it's talking about paper read by true and first inventor before a learned society or published. Learned society is that this It has not been defined, but what we understand as a learned society is that learned society is a group of people who are gathered or who are working for the enhancement of the science or scientific knowledge, and their transactions are generally not public. It is only for the consumption of the members and for discussion purposes only. This is a general definition of learned society. In other jurisdiction, we have not found the learned society definition in India. It has not been defined. Now, so anticipation is, it says that you will get 1 year. If there is a government who has notified an exhibition that this is a protected exhibition. If you display here, you are protected by the provisions of this section, and your invention will not be considered as being anticipated under this. If that has been notified, this section's protection has been extended to that particular exhibition, then because of this exhibition, there can be 3 things. Any use, your demonstration, your display, any use, or whatever is happening there, or any publication after that because of the consequence of that, or any use because of that, which you have not consented, all those things cannot be cited against your invention. It will not be considered anticipating you. Then comes paper read by a true advisor. If in a learned society or in its transactions, your paper is being published with your consent and you have read it there, then also it will not be considered as anticipation. Then comes anticipation by public working. Public working is, one thing is that within 12 months you have to file. Right. In this anticipation of public working, yes, all these disclosures, your work on, yeah. The only thing is that it should not be more than 12 months. Okay. That your patent has been filed within 12 months from the date of this exhibition or that reading or publication of paper, whatever it was, it should not be more than 12 months. 31 talks about time, please remember. And same thing in 32 also talks about times, and the time is same, 1 year. So it talks about that an invention claimed in complete specification shall not be deemed to have been anticipated by reason only of if you have worked in public working. Public working is, as I told you earlier, that you can commercially work in, you can publicly work in India, but it should be under with your consent, and this working is for reasonable trial, and it is reasonably necessary. If this is not there, you will not get the protection of this clause. So same thing. So we said, I have just given you a gist of the same. The work with the consent, reasonable trial and trial was necessary. Public working was within 12 months before the priority date. Then comes 33. 33 is simple. It deals with the provisional specification and any use after that. Okay. So there are 1 and 2 part. These are very simple. 1 talks about that. Suppose there was a provisional specification filed within 12 months, your CS was to be filed, and after this PS, you have published something. Or if you go for CS1, you have filed a complete specification, but you have converted it to a provisional specification, and after that, use has been done or publication has been done. So all that will be not considered as anticipated. Then comes basic application. See, basic application is in convention applications. So if there was an after filing of the basic application, after the priority, if your publication it has been published or used, your invention will not be considered as anticipated. This is the crux of 33. And The effect is simple that because of this, if you fall under 29, 30, 31, 32 or 33, 33 control will not refuse to grant a patent, patent shall not be revoked and invalidated. It will not be considered as anticipation. So 33 talks about this effect in its own section, while 29, 30, 31, 32's effect is written in 34. So this is, I would like to wrap up here because otherwise it will be too much information for you in a day. So